Offshore asset protection strategy. You will evaluate lawful cross-border structures that reduce the enforceability of private civil claims against financial assets while preserving tax compliance and ethical duties. You will distinguish between hiding and shielding. Hiding invites criminal exposure. Shielding uses jurisdictional differences, fiduciary distance, and prudent banking to ensure that a domestic court order does not equal immediate asset seizure. You will calibrate design toward deterrence, making collection so costly and uncertain that a rational creditor settles within policy limits rather than pursuing overseas litigation. Footnote: this section reframes offshore planning as defensive civil procedure within the bounds of financial regulation and tax law. Why bank location alone fails. You may believe a foreign account defeats a domestic judgment. It does not when you still hold unilateral control. A court can enter a repatriation order that compels you to sign releases and wire funds. If you can comply but refuse, civil contempt can follow until you purge the contempt by performance. In practice, a FBAR offshore account is a chain link fence around a visible car. The court reaches you, and you unlock the car. The problem is not geography. The problem is legal control. Until you separate beneficial ownership from day-to-day dominion under enforceable foreign law, location alone offers thin protection. Footnote: this section explains that absent fiduciary distance a judge compels you personally, rendering mere foreign placement ineffective. Core definitions and enforcement mechanics. You should master 3 concepts. 1. A repatriation order is a command that you return assets to the forum within a set time. 2. Civil contempt enforces that command through fines or jail until you comply, which depends on present ability to perform. 3. Impossibility is a defense only when performance is genuinely beyond your power, not when you engineered obstacles after the fact. Asset protection works lawfully only when the loss of personal control was established before trouble, documented in governing instruments, and recognized by the foreign forum. Footnote: this section defines the levers courts use so you can design around them without frustrating the administration of justice. Architecture of a resilient structure. You begin with a foreign law trust formed in a jurisdiction that does not recognize outside money judgments. The trust owns one international limited liability company that holds bank and brokerage accounts. During calm seas you may serve as company manager to transact ordinary business. Upon legal duress a licensed offshore trustee succeeds management under written duress provisions, declines foreign orders that local law forbids, and maintains custody consistent with fiduciary duty. This separates you from immediate command while preserving lawful administration. Records, accounts, and minutes must evidence routine non-litigation use so that form aligns with substance. Footnote: this section sets out a trustee-led structure that shifts control under stress without abandoning compliance or documentation. Jurisdictional filters and safety test. You will choose forums using 5 filters. 1. Sovereign independence from automatic recognition of outside civil judgments. 2. Political stability and high per capita income that correlates with predictable courts. 3. Strong bank capitalization with conservative Tier 1 ratios to reduce bail-in risk. 4. Confidentiality statutes that criminalize unauthorized disclosure while honoring lawful tax reporting. 5. History of resistance to extrajudicial pressure and careful treatment of foreign subpoenas. Danger signs include expedited reciprocity regimes, currency controls, volatile cabinets, and regulators that advertise cooperation first and due process later. Footnote: this section gives you a checklist to grade forums on enforceability risk rather than marketing slogans. Preferred banking hubs under these filters. You will consider continental Europe for deep capitalization and statutory bank secrecy that survives ordinary private claims while observing international tax reporting. You will evaluate a microstate in the Alps for civil law independence and high liquidity buffers suited to dynastic holdings. You will assess a Gulf financial center that runs common law courts in English and requires relitigation before enforcement. You will review an Asian trade hub with strict prudential audits and discretionary registration of foreign money judgments, recognizing account opening hurdles for non-residents. Across all, the trust layer remains the primary shield and the account is the vault, not the wall. Footnote. This section recommends hubs whose courts require new proceedings and whose banks pair privacy and private disputes with tax transparency. Jurisdictions with fast enforcement pathways. You will avoid first-world peers that register or recognize outside civil judgments through treaty or statute with minimal review. In such places, a domestic creditor can domesticate a money judgment and garnish within weeks. Case reports document brokerage seizures after swift registration in provincial or national courts. Likewise, common law comity in some countries yields expedited garnishment once due process is shown. These are excellent for commerce yet poor for asset insulation. If you must hold operating accounts there, do not park surplus reserves beyond operating needs. Footnote. This section cautions that friendly trade partners often speed enforcement, turning bank location into a creditor shortcut. Why Trust Plus Company beats a FBAR account. You win deterrence when you cannot lawfully comply with the demand to remit because you do not hold the switch. A foreign trustee, bound by local statute, refuses to act on foreign court papers and honors only orders of the home court. Some statutes impose beyond a reasonable doubt burdens for intentional fraud and short limitation periods, forcing a claimant to start over with large bonds and unfamiliar rules. You must still avoid transfers made in anticipation of a specific claim, since fraudulent transfer law and look-back windows can unwind sham moves. Build early or do not build. Footnote. This section shows that control transfer and forum selection create lawful impossibility while warning against reactionary transfers. Implementation Roadmap. You draft a trust deed with duress clauses, appoint a regulated offshore trustee, and form a wholly owned foreign company. You open accounts in a vetted bank that welcomes fiduciary ownership and supports multi-currency custody. You fund by wire with clean source documentation and contemporaneous resolutions. You document an investment policy, routine disbursement procedures, and annual reviews. For real estate you pair equity stripping or separate holding structures with domestic compliance. For digital assets you define custody, keys, and exchange risk within trustee policies. Footnote. This section converts doctrine into steps that create records showing ordinary use rather than emergency evasion. Tax and regulatory compliance. You will treat offshore as off-limits to private creditors, not off-limits to the Revenue Authority. You will file foreign account and asset reports where required, include trust and company information returns, and respect controlled foreign corporation rules. You will preserve complete audit trails for wires, valuations, and trustee fees. You will avoid promoters who promise secrecy from tax reporting, which invites criminal exposure. Proper planning lowers civil collection risk while leaving taxation unchanged. Footnote. This section distinguishes creditor privacy from tax transparency and directs you to file all required reports. Costs, proportionality, and settlement dynamics. You should expect low five-figure formation and annual maintenance for trust, company, and trustee. That cost must be proportionate to the assets at risk in the litigation climate of your trade. The economic thesis is not invincibility. It is leverage. By converting a one-step domestic levy into a multi-step foreign lawsuit with high proof and bonding, you move a claimant toward insurer-paid resolution. You also preserve optionality to offer reasonable settlements without exposing your entire balance sheet. Footnote. This section sets realistic budgets and explains how procedure, not bravado, creates bargaining power. Governance, stress testing, and limits. You will run an annual fire drill. You will simulate a demand letter, trigger duress procedures on paper, and time trustee responses. You will audit bank capital ratios and jurisdiction risk scores. You will update letter of wishes and beneficiary schedules. You will accept limits. No plan defeats criminal forfeiture, tax liens, or intentional fraud findings. Your objective is to shape rational settlement in civil disputes, not to obstruct lawful authority. Build early, Document well, and maintain quietly. Footnote. This section commits you to rehearsal and acknowledges legal boundaries that no private structure can cross.